to address the court and call His Excellency Mr. Ammar Al-Hassan to the podium.
Mr. President, distinguished members of the esteemed court, it is an honor and privilege to address the esteemed court today on behalf of the Syrian Arab Republic at a very sensitive time, while the Palestinian people find themselves with no real protection. In this oral statement, I will present my country's position regarding the questions related to this case in accordance with what was stipulated in the relevant General Assembly resolution. Out of respect for the time allotted to me by the esteemed court, I will get straight into presenting my country's legal position. Mr. President, distinguished members of this honorable court, the theory of occupation in principle contradicts all the values, ethics, laws, and charters that humanity has established throughout its long history. In order to preserve human dignity and sanctity, to maintain international peace and security, and to save the world from the scourges and sufferings of wars. In fact, the crime of occupation has been and continues to be the most serious and heinous crime in the history of mankind, taking into consideration the occupation's flagrant violation of the Charter of the United Nations, the provisions of international law, international human rights law, and international humanitarian law, and all international charters and customary rules. In fact, occupation acts primarily on the basis of usurping land by force, which is essentially prohibited under international law and the provisions of the Charter. It also acts on the basis of suppressing the will of the people, seeking to degrade their dignity and deprive them of their basic rights. Today, the practices of Israel, the occupying power, are definitely the clearest reflection, unfortunately, of the failure of the international community to prevent heinous crime of occupation and to ensure the implementation of the relevant resolutions of Security Council, General Assembly, and the Human Rights Council. The Syrian Arab Republic stresses the need to hold Israel accountable for its grave and continuing violations of the provisions of international law, the Charter of the United Nations and its relevant resolutions, and the provisions of international humanitarian law, including provisions in Section 3 of the Fourth Geneva Convention of 1949, Article 47, and what follows. Mr. President, distinguished members of the Court, we are here today to make sure that they, the occupiers, do not get away with impunity. The first question before the distinguished Court today relates to one of the most important and noble human rights, which is the eternal and fundamental right to self-determination. The right to self-determination is a fundamental human right that is enshrined, among other international instruments and conventions, in Article 1, Paragraph 2 of the Charter of the United Nations, providing that each state shall, and I quote, refrain from any forced action depriving peoples of their right to self-determination, freedom, and independence, end of quote. And that each state shall, again I quote, encourage through joint and unilateral action the realization of the principle of self-determination of peoples." End of quote. This right is also reiterated and affirmed in common Article 1 between the Covenant on Economic, Social and Cultural Rights and the International Covenant on Civil and Political Rights, which obliges states that are parties to these covenants to promote the realization and respect of this right in accordance with the provisions of the Charter of the United Nations. Israel violates this right through, for example, the establishment and continued expansion of illegal settlements in the occupied Palestinian territories, including Jerusalem. We note, in particular, the discriminatory Israeli legislation of 2018, or what's so-called the Basic Law, Israel as the nation-state of Jewish people, which recognizes the right to self-determination exclusively for the Jewish people, denying the right of the Palestinian people to self-determination on their land and in their homeland. I shall now turn to talk about the legal consequences. Israel must be held accountable for its violations of international law and United Nations resolutions. Israel must put an immediate end to the violation of its international obligations by halting all actions and measures that prevent and/or impede the exercise of the Palestinian people's right to self-determination, including putting an immediate end of the occupation in all its forms. For third states, since the right to self-determination is an erga omnes argument and obligation on all subjects of international law, all states must respect it and seek to achieve it. It is also the responsibility of all states, consistent with respect for the United Nations Charter and international law, to immediately put an end to the obstruction of the Palestinian people's exercise of their right to self-determination. The United Nations, in particular the General Assembly and the Security Council, should consider the additional procedures and binding international legitimacy tools stipulated in the Charter that are required to put an immediate end to any obstruction preventing the Palestinian people from obtaining their right to self-determination, and to take the necessary measures in order to ensure the implementation of its relevant resolutions without any further delay. With your permission, Mr. President, I shall delve into the part of the question regarding prolonged occupation, settlement, and annexation, along with changing the demographic composition. The illegal Israeli settlements and the system associated with them are based actually on a dual process. On one hand, the forced displacement of Palestinians and the confiscation of their lands, and on the other hand, the transfer of Israeli settlers and the construction and expansion of settlements on confiscated lands. International humanitarian law prohibits the forced displacement of the occupied people and the transfer of citizens of the occupying power to the occupied territories, as confirmed by Article 49 of the Fourth Geneva Convention that provides for the protection of civilians in the time of war. Thus, forced displacement and transfer of citizens by the occupying power constitute grave violations under Article 147 of the aforementioned Convention. Indeed, the actual annexation of parts of the occupied Palestinian land is embodied through a continuous gradual process involving the implementation of many measures and actions that include, among others, settlements' size, infrastructure, and location, which indicate the purpose to make them sustainable. Israeli government plans and directives that allowed the establishment and expansion of settlements. The legislation that enacted a dual legal system in the occupied territories in favor of the settlers at the expense of the occupied people, including the Basic Law of 2018, aka Israel as the nation-state of the Jewish people. Another example, Public statements of Israeli officials demonstrate to the fact that the settlement and the system associated with them constitute a deliberate policy of obtaining a permanent presence for the annexation of the territories and confirm that the actual annexation had already taken place. The guidelines and coalition agreement of the new Israeli occupation authorities sworn in on the 29th of December 2022, in which they explicitly declare that the Jewish people have an exclusive and indisputable right to all areas of Israel and undertake to strengthen and develop settlements throughout what they called the land of Israel, in the Galilee, the Negev, the West Bank, and in the occupied Syrian Golan, despite the confirmation by the United Nations Security Council Resolution 497 of 1981 that provides, and I quote, "The Israeli decision to impose its laws, jurisdiction, and administration in the occupied Syrian Golan Heights is null and void and without international legal effect." End of quote. Mr. President, distinguished members of the court, in 1980, the Israeli Knesset adopted the Basic Law on Jerusalem, which states that Jerusalem, whole and united, is the capital of Israel, effectively annexing the city in flagrant violation of international law and of the city's own international status. In response, the United Nations Security Council adopted Resolution number 478, which declared that, again I quote, "All legislative and administrative measures and actions taken by Israel, the occupying power, which have altered or purport to alter the character and status of the holy city of Jerusalem, and in particular the recent Basic Law on Jerusalem, are null and void and must be rescinded forthwith." Mr. President, since then, the Israeli occupation authorities have worked to consolidate further annexation instead of reversing it. I shall now talk about the legal consequences. Israel is obliged to immediately stop all its violations of its legal obligations in Jerusalem and all other occupied Palestinian territories. The cessation of such violations entails, inter alia, the dismantling of illegal structures, including settlements and the apartheid wall, the cancellation or the activation of all legislative and regulatory acts adopted by Israel with the aim of building illegal settlements and normalizing said system. Also, Israel is obliged to make reparation for the damage caused to individuals concerned through restitution and compensation. Regarding the legal consequences for third states, the United Nations General Assembly, in its resolution 77/25, called on all states, inter alia, first, not to recognize any alterations to the pre-1967 borders and to ensure that agreements with Israel do not imply recognition of Israeli sovereignty over the territories occupied by Israel in 1967. Second, not to provide aid or assistance to illegal settlement activities, specifically with settlements in the occupied Arab territories of Palestine and the Golan, in line with Security Council Resolution 465 of 1980. For the United Nations, the international organization, in particular the General Assembly and the Security Council, should consider the additional measures and binding international legitimacy tools stipulated in the Charter that are required to immediately end the illegal occupation and take the necessary measures to ensure the implementation of its relevant resolutions without any further delay. Your Honours, just as a reminder, today we are talking about a huge record of UN resolutions that Israel keeps violating. Actually, when it comes to the Arab-Israeli conflict, we are talking about 180 resolutions of the General Assembly and 227 resolutions of the Security Council. Mr. President, allow me now to move on to the part of the question regarding discriminatory legislations and measures. Since its inception, Israel has adopted various discriminatory legislations aimed to ensuring its control over the maximum geography with the minimum possible number of Palestinians. The United Nations Human Rights Council has described the Israeli discriminatory measures as, and I quote, "a combination of movement restrictions consisting of the wall, checkpoints, a permit system that affects only the Palestinian population, and the application of a two-tier legal system that facilitated the establishment and consolidation of settlements, and other violations and forms of institutional discrimination." End of quote. The United Nations General Assembly has always, and for many years, condemned in a large number of resolutions the discriminatory policies and practices of Israel, the occupying power, against the Palestinians as well as the Syrians in the occupied Syrian Arab Golan. These policies and practices include, according to these resolutions, killing and injuring civilians, arbitrary arrest and detention, in addition to forced displacement of civilians, transfer of settlers to the occupied Palestinian and Syrian territories, destruction and confiscation of civilian properties, and demolishing homes. Your Honors, in the devastated Gaza Strip, long before the 7th of October 2023, Israel practices racial discrimination towards the Palestinian population in the form of its ongoing blockade. The discriminatory nature of the blockade actually imposed on the Gaza Strip was recognized by the United Nations Committee on the Elimination of Racial Discrimination. This blockade was found to violate the Convention on the Elimination of Racial Discrimination. The actions of Israel are part of a large-scale, repressive, organized and systematic regime. Such actions have been identified as apartheid after thorough factual and legal examination by the UN Special Procedures and by various international organizations. Apartheid is most manifested in the occupied Palestinian territories, including Jerusalem, where illegally located settlers benefit from far-reaching privileges at the expense of the basic rights of the Palestinian people. For legal consequences, Israel is obliged to immediately repeal all legislations aimed at or leading to the maintenance and perpetuation of apartheid and racial discrimination against the Palestinian people. This includes the termination of its settlement activities, the cessation of all discriminatory policies and practices, along with due compensation to all those affected by these policies and practices, including Palestinian refugees. For third states, they must not recognize this illegal situation and must not provide any help or assistance in any way that may sustain and maintain this situation. For the United Nations, especially the General Assembly and the Security Council, the international organization should consider the additional measures required to end the apartheid system established by Israel and should take the necessary measures to ensure the implementation of its relevant resolutions without further delay. After this review, allow me, Mr. President, to present my country's legal position on the second question presented before the distinguished court in accordance with the relevant General Assembly resolution. It's about illegal status of occupation. The acts and practices of occupying powers are strictly regulated by international law and international humanitarian law. Article 49, paragraph 6 of the Fourth Geneva Convention stipulates that, and I quote, "The occupying power shall not deport or transfer parts of its civilian population to the territories it occupies." End of quote. While the occupying power is obliged under international law to administer the territory for the benefit of the people under its occupation, Israel administers the territory only for the benefit of its settlers and even to ensure the sustainability of the illegal occupation of others' land. While annexations or claims of sovereignty over territories under the interim administrative authorities of the occupying power are strictly prohibited, Israel has sought to exercise fait accompli sovereignty over Jerusalem and the occupied Arab territories. Mr. President, members, distinguished members of this honorable court, we believe in the first place that the Israeli occupation in and of itself should be considered absolutely illegal and that we should not be satisfied with only and merely describing its practices and policies. Allow me now to move to the legal consequences. The legal consequences constitute Israeli commitment to an immediate and unconditional end to its occupation of the Arab territories in Palestine and the rest of the occupied Arab territories, including the Syrian Arab Golan, in addition to providing compensation to all those affected. For third states, it is imperative to commit to support all efforts exerted to end the illegal occupation without delay and to refrain from any actions that contribute to maintaining the illegal situation. For the United Nations, in particular the General Assembly and the Security Council, it should consider the additional measures and binding international legitimacy tools stipulated in the Charter that are required to ensure the implementation of the relevant resolutions without any further delay, including the immediate and unconditional end to the Israeli occupation of the occupied Arab territories in Palestine and the Syrian Golan. The Honourable Judges, the Syrian Arab Republic affirms the principle that states shall not obtain legal rights from unilateral acts that do not comply with international law. Syria also re-emphasized the temporary nature of the occupation and that even if it is a fait accompli, this does not and will not give the occupying power the right to acquire sovereignty over the occupied territories, no matter how long this brutal occupation lasts. Syria reiterates that the stability of the Middle East and the credibility of the United Nations system, including the esteemed court, require taking measures to ensure the implementation of all relevant international international resolutions to end the Israeli occupation of all occupied Arab territories in accordance with the relevant United Nations resolutions. Mr. President, esteemed members of the Court today, in this case, does not create new rights, but rather reveals rights that are violated by Israel every day since 1948. Israel is not only committing the horrendous act that we have just mentioned, but we are currently witnessing Israel committing genocide in the occupied Gaza Strip, attacking Syria, attacking Lebanon, and committing war crimes and crimes against humanity. In fact, one of the reasons for Israel's consideration of itself as being above the law is that it has been carrying out illegal occupation and committing crimes for 75 years without facing accountability or any sort of consequences. Today, it has become imperative for all states to convince or to show Israel, the occupying power, by all possible legal means that it does not have a green light to annex more occupied territories, expel their indigenous people, and build more illegal settlements. Most importantly, convincing and showing Israel that there will be no peace, no security or stability for all and equal without ending the occupation and establishing a viable and sustainable Palestinian state that possesses full competence and authorities like all member states of the international community. The continuance of these violations means more Israeli escalations vis-à-vis the Palestinian people exercising their legitimate right to resist the occupation. Many decades have passed, and the suffering of the Palestinian, Syrian, and Lebanese peoples under the Israeli occupation continues, mainly due to the absence of a decisive and credible political will that is keen to implement the provisions of international law. Your Honours, today, and for all these reasons, and for the sake of genuine peace and unshakable justice, we look forward to the role of jurists who took it upon themselves to equally uphold the provisions of the law in order to contribute to achieving peace and justice to those people suffering under the most violent, most tyrannous, and most oppressive form of occupation in the history of humanity. Thank you, Mr. President. Thank you, distinguished members of the Court.
I thank the delegation of the Syrian Arab Republic for its presentation. J'invite la délégation.
I invite the next participating delegation, that's Tunisia, to address the Court and call